Questo lo mettiamo qua. Bene, perfetto. Allora direi che possiamo iniziare. Ok, hi everybody, can you hear me? Please give me a confirmation also for the participants.
Yes, Professor.
Okay, thank you very much. Okay, so we can proceed. Welcome to everybody. I thank very much all the speakers to having accepted our invitation for this seminar. And also, I would like to thank all the participants to be here this morning. Due to this unlucky weather alert, this regional warning, we could not hold the seminar in person. So we have to turn our mood into a virtual one, but I hope that this will not harm in any way our seminar and the proceedings of this seminar. In any case, we will publish the result of this seminar, so all the speakers are aware about this, and they give me the availability to draft a paper, to submit a paper for this seminar. So we will publish this proceeding book that I will, of course, spread to all of you. We have this very interesting subject, this interesting issue today. I do not go into details because we have a fantastic introduction of Fiorella Lunardon, so she will give us a brief outlook of the topic. So I don't say anything. I reserve to make an intervention during the debate. For now, I let to Fiorella the floor, and I thank her especially for accepting either to chair this session. Okay, thank you, Fiorella. The floor is yours.
Good morning, everyone. First of all, I wanted to thank Professor Pizzo Ferrato for kindly having invited me to this in-depth seminar on a crucial topic, not only for our country, but also for every other country in Europe. The topic is the implementation of the recovery plan and the transition toward the digitalization of production systems. And we ask, what role, and this is the title of the seminar, what role for the social partners in the light of the challenges posed by these topics? The trade unions and the business associations that are our social partners are involved in the forefront of this challenge due to their responsibility recognized by our Constitution in regulating social and labor relations. They, trade unions and business organizations, are confronting a profound change in the strategies and practices inherited from the last century. Decree number 77 of 2021 instituted a specific tool for this purpose, the so-called the Permanent Economic and Social Partnership Table, where the major organizations representing society are present together with the representatives of local authorities, regions, and universities. With this law, unique on the European scene so far, Italy wanted to give a stable and institutional recognition to the participation of social organizations in the implementation of the recovery plan. Today, the task is even more demanding than that required by the social pacts of the past. For example, the agreement of July 1993, stipulated in analogous moments of crisis. Today, in fact, the goal is more ambitious because it must build, because trade unions and business organizations must build the conditions to create a new model of growth and society. So, to come in medias res, as we say, today we have three great problems that affect our system of collective bargaining. One, the measurement of representativeness of the trade union in the private sector. The current division and fragmentation, not only of trade union organizations, but now even more of business organizations, have led to an ever-growing number of pirate contracts concluded, that is stipulated outside the most representative confederations. The fight against pirate bargaining requires first of all an identification of the representative consistency of both stipulating organizations through the definition of certain criteria of measurement. As is known, a first step necessary to strengthen the contractual system has been taken for the trade union side in Italy with the so-called TU. We can translate a unique text of 2014. But it has not yet been taken for the definition of criteria of representativeness of the employers' organizations, despite the attempts made by our organism, that is the CNEL, il Consiglio Nazionale Economia e Lavoro. Sorry for the Italian, but is like that. The effectiveness of these rules can be imposed only in sectors where the organizations of the stipulating parties are sufficiently consolidated to enforce them, but not in areas where those rules are contested by different organizations that take advantage of their specific position, that is to be outside of the perimeter, to negotiate different and often worse terms. For example, salary to the downside, and so on. And this is the first problem. And I think that this problem affects more or less the regulation of other countries. Second question. The effectiveness of collective agreements, above all those regarding the minimum wage. Most European countries have adopted the legislative solution, while other legal systems, including the Italian one and those of the Nordic countries, have historically preferred to use collective bargaining and only collective bargaining for this purpose. The so-called erga omnes extension of contracts, or at least of basic wage levels, is for some, though not for everyone, the only solution to the problem. In my opinion, the best solution is instead to strengthen collective bargaining by providing for legal mechanisms that take a reference or a parameter the minimum tables contained in the national collective agreements signed by the representative parties. In any case, an essential condition for proceeding in the direction indicated is, as I said above, to acquire unambiguous and effective criteria of representativeness of both negotiating parties. 3, and this is the third and last problem, the perimeter of the category. Still more difficult would be the intervention in the areas of application of collective bargaining for the category in order to ensure a closer correlation between the collective agreements applied and actual business activity. However, the parties' commitment to ensure compliance within the perimeters of collective bargaining and its contents by preventing non-representative subjects from arbitrarily forcing these perimeters is, as Professor Treu says, an optative statement because it expresses a desire, in this case unreal, that it's a problem very, very difficult. And I think it's difficult also for other countries. And then 2 words about digitalization. As regards digitalization of working conditions or of productive systems, we must remember the framework agreement stipulated between the major European trade union and business confederations. This framework underlines the need to establish procedures and tools agreed between the parties aimed at ensuring that every use of digital technologies and artificial intelligence respects the rights of workers and the principle of human control. In this regard, the proposal of the directive for platform workers focuses on information and consultation rights, establishing the obligation for platforms to inform and consult workers' trade unions about the algorithmic decision-making mechanisms. It also requires digital platforms to provide information on working conditions applicable to contractual relationships. Finally, Article 8 recognizes the right of workers to obtain from the platforms explanations that justify decisions taken by automated systems that significantly affect their working conditions and to request human reviews of the decisions so taken. The challenge of finding adequate tools to direct the use of digital technologies in the name of human control, as required by the European Framework Agreement, primarily challenges the innovation capacity of the social partners. The history of our industrial relations confirms that the main innovations present in our legal systems have been the joint result of three factors: collective actions, reform interventions, and support from national legislators. And I'm done. Thank you for your kind attention. I will now leave the floor to our guest speaker, Professor Philippe Dorsmont, who I thank and who I will listen very carefully. Please.
Dear colleagues, I'm very honored to be here. Throughout my life, I have moved from universities recently founded to more ancient universities. And today I have the honor to be hosted by the oldest university of Europe. Each time I had the impression not just to move to more ancient universities, but primarily to universities much more dynamic and more in touch with contemporary societies, but always honoring the values inherent in the very idea of an academia. I had a wonderful week. Due to the weather, I immediately felt home, and the hospitality of Alberto Pizzoferrato and his colleagues was unsurpassed. Today, they gave me a mission impossible: the task to define what EU collective labor law is about, and even more, to explain the underlying principles and how EU labor law evolved. I don't know whether I will succeed in sketching the underlying principles and how it evolved, but I will talk about perhaps the most complicated question: the definition of EU collective labor law. When I started my academic percorso, the Maastricht Treaty, 1992, signed 1993, entering into force, had just recently been adopted. The Maastricht Treaty was a defining moment in the construction of the European Union for two reasons. First, it created a momentum at EU level to shape a paradigm of labor law which is very reminiscent to labor law as we know it at domestic level. Because labor law for us is a set of rules, obviously applicable to employment relations, but based upon a reference to human dignity, exemplified in casu by references in the Maastricht Treaty to the European Social Charter, to also the Community Charter of Fundamental Social Rights of Workers. And in fact, this evolution coincided by chance in 1992, 1993, with the constitutional recognition in my small country of economic and social rights. Rather late, but okay. And then secondly, this Maastricht Treaty enshrined an important idea, if about us, not without us. The European Commission, envisaging directives in the field of social policy, became bound by an obligation to inform and consult what they call management and labor, and not social partners in the English version, prior to adopting directives. And they empowered the actors to produce legal precepts, legal standards, which had to be implemented either in an autonomous way by other collective agreements or in a heteronomous way by a directive. In some, EU social law moved away from a paradigm of a market rationale, market correction, market institution, to adopt rules to a paradigm aimed at promoting fundamental social rights of workers in their own right. Today, I am asked to deal with what has been called the principles evolution of EU collective labor law. And this question, in a way, is deeply rooted in the classical bifurcation, the classical dichotomy of labor law at domestic level, which once upon a time tended to be presented as a diptych. You know, there was individual labor law and there was collective labor law. Obviously, now a labor law at domestic level cannot be presented anymore as such a diptych. Other panels have been added. We are dealing with a politic, but still collective labor law continues to be extremely important as a part of domestic labor law and also as an academic discipline. So we see that collective labor law at national level is subject to manuals, is subject to courses in many universities. And I want to stress this importance: labor law, collective labor law as a branch, and collective labor law as a discipline for teaching, for research. Now, if we want to define the principles and the evolution of EU collective labor law, we first must wonder what is collective labor law and what is EU collective labor law more specifically. And the most easy question might be, is EU collective labor law an academic discipline? Because my answer would be, it's not an academic discipline. There would be a sign of an academization of EU collective labor law as an academic discipline if it would be offered as a specific course in a program, or if it would have loads of manuals dealing with EU collective labor law. Now we have some manuals dealing with parts of EU labor law, for example, in the field of non-discrimination, because there are also a set of more or less consolidated directives, but we don't really at this stage have loads of manuals dealing with EU collective labor law, and we don't really have in general loads of directives systematically dealing with issues of EU collective labor law, perhaps with the exception, I must say, of information and consultation worker involvement. In fact, I only know of one book, which is called EU Collective Labor Law, which is written by my colleague, distinguished colleague Beryl ter Haar, and by my colleague Attila Kuhn. They are the editors. A lot of people, also Italian scholars, were involved, like Eduardo Ares, Jacopo Senatore, Vincenzo Pietro Giovanni. And the cover of the book, which I cannot show, but I would suggest you look it up in Google, is interesting. It's confusing because the book is not just about EU collective labor law. It also deals with collective labor law of the ILO, of the Council of Europe, trying to articulate, of course, these sources with EU collective labor law. But the image suggests that the pace and the rhythm of EU collective labor law is slow, because we see a number of ants, not ants, but ants, Warnike, working together. They have work ethics, of course, and they have solidarity. And they're trying to move slowly a big apple. Now, the way in which collective labor law is fleshed out in manuals of EU labor law is also interesting from an academic perspective. And one does not see a clear-cut picture. We have handbooks who do not refer at all to the notion of collective labor law. They just deal in a couple of chapters with issues of collective labor law without referring to collective labor law. And we have also books like the book of Carinci Pizzoferrato with a nice chapter indeed by the Professoressa, where the notion collective labor law is being used and where a lot of subjects are being dealt with under that heading. But there are always problems because in allocating some issues of worker involvement in the case of restructuring, sometimes this is done outside the chapter on collective labor law, and even in the EU collective labor law book, it's interesting to see that there is a chapter on collective bargaining, which does not deal with the EU social dialogue, but it deals with the impact of EU law on the collective labor law of the member states. But let's leave this rather solipsistic reflection on collective labor law as a discipline for academics, and let's talk perhaps about the reality. Why should we talk about something vulgar as the reality? Because diritto sindacale, collective labor law at domestic level is, of course, a way to deal with a phenomenon which is called industrial relations. Industrial relations which can be construed as already something legal, as an ordinamento intersindacale, and then the job of the specialist of collective labor law would be to understand the relation, the relation between this phenomenon, that is industrial relations, and the legal order of the state. So we should wonder how about the relation between the law, EU law, and a phenomenon of industrial relations taking place at EU level. That is the idea. Do we see something of that nature? Now, it's important to stress that the relation between law and industrial relations is not a linea recta relation. The mere fact that phenomena of industrial relations are being outlawed by a legal order will not per se amount to the non-existence of industrial relations. Combinations, strikes have occurred at times when they constituted criminal offenses, during the Ancien Regime, during the French Revolution, and unfortunately once more in the fascist era. But still, they occurred. Furthermore, the mere fact that there is a framework which is facilitating phenomena instead of prohibiting them is not a guarantee that these phenomena will actually emerge. It is no secret that we have a framework which allows us to give an efficacia erga omnes to collective agreements at European level, but the European social dialogue does not really produce a lot of these agreements anymore. I mean, if the EU Commission is reluctant to adopt a genuine social policy agenda, there will be no bargaining under the shadow of the law at European level. And the shadow is becoming even more pale if the impression is given that the Commission will not per se implement these agreements, if indeed they would be concluded. And the absence of a regulatory framework is not an obstacle to the emergence of some industrial relations phenomena. We already had European Works Councils before the EWC directive was adopted. And we have loads of so-called transnational company agreements, but there is no legal framework. All in all, it is safe to say that industrial relations have developed at a comprehensive EU level, 27 member states, but also at a less comprehensive transnational level. We have industrial relations at the level of multinational groups of undertaking. We have the EWCs, remember, we have these transnational company agreements, and we have at the EU level, we have the sectoral and the intersectoral European social dialogue. And in fact, we even have new actors, unprecedented actors, like the EWC, special negotiating bodies, and obviously the European sectoral and intersectoral social partners. I will use the term because it's used in other language versions. And the only thing which is actually really missing, and that is striking to me, is the strike. We hardly see pan-European strikes. There was, of course, the good practice of the boycott, which was at the heart of the Viking case, which was a pan-European solidarity action. But in the Laval case, such a pan-European solidarity was missing. There was something which you could call a solidarity strike, but it was not really a secondary action because the primary action was not there. But what is EU collective labor law then? We have seen, okay, there are industrial relations taking place at transnational European level, but what is then EU collective labor law? Well, the object of EU collective labor law cannot just be reduced to the legal rules regulating this new phenomena of transnational and European relation, which is already a legal thing in its own right, but which, emerges the question, how does the EU law deal with this phenomenon? EU law is not just about this transnational or European level of industrial relation. It also tends to harmonize national labor law, and it affects employment relations which are not which do not have this external element, which are completely evolving within the boundaries of a nation state. EU labor law cannot be reduced to private international law. Although private international law can be relevant, for example, we have a rule saying that the law applicable to issues of extra-contractual liability in cases of strike is the lex locus actus, or the lex locus non laboris, because the point of a strike is that there is no action, of course, and it's not the law where the damage occurs. And this is extremely protective for people who have recourse on strike. EU law does affect industrial relations at a purely domestic level. Indeed, EU law is extremely important for the issue of worker involvement, this process of information and consultation at company level. And I think that here EU law is extremely complete. We have specific scenarios of restructuring where information consultation needs to take place. Of course, transfer of undertaking, collective redundancy, but also there is a general principle that in case of decisions, any decisions being envisaged which severely affect the interests of workers, there should be information and consultation. And there is also this idea of a recurring information and consultation, which can be retrospective and prospective. Now, EU labor law has also restricted the internal autonomy of trade unions at purely national level because they cannot discriminate workers who want to join them First, historically, on the basis of their nationality, but only in the context of free movement. And now, in general, they cannot discriminate workers wanting to join on the basis of, you name it, sex, race, age, sexual orientation, handicap, religion, or belief. And I salute this reform. I don't think this is a problematic restriction of their internal autonomy. There has also been a restriction of the collective autonomy of trade unions, because if there would be clauses in collective agreements which are discriminatory on the basis of the same grounds, they will be null and void. Null and void. There's a clear-cut sanction in the directives. Now, that is all positive, but the question also arises, does EU law also protect the workers who are affiliated to trade unions against discrimination? Does it protect trade unions against acts of interference? To say it in other words, do trade unions also profit from the idea of non-discrimination? Until recently, I would have said no, EU law does not protect them. But the recent directive on adequate minimum wages, in a specific context of bargaining of these adequate minimum wages, pays tribute to these two principles, although the union has no competence in the field of freedom of association. Now, another object of EU collective labor law is not just dealing with its transnational industrial relations, is not just dealing with harmonization of collective labor law at national level, but could also be the law of the industrial relations within the EU institutions. What about industrial relations of these poor civil servants working for the EU institutions, especially in my hometown, Brussels? And when I was concluding a volume together with Klaus Loescher on the Charter of Fundamental Rights of the European Union and the Employment Relations, I, together with Klaus, had to admit that the right to strike of Article 28 was of no use to the workers outside the EU institutions. These workers could not, as such, invoke it neither against their states, neither against their employers. And the only ones who could, in theory, invoke Article 28 were these poor civil servants of the European Union. And in fact, there's a recent judgment, the Aquino versus European Parliament judgment of the General Court, where Article 28 was used to save interpreters working for the European Parliament who were requisitioned to interpret, although they had announced a strike. And this requisitioning was deprived of any legal basis and therefore was not prescribed by law, and the General Court annulled it, which is interesting, but this is only helpful for the happy few, of course. Now, EU collective labor law is also about another thing. It's also about a phenomenon which we call negative integration. You know, when EU law, especially EU economic law, is mobilized to downgrade elements of social protection offered by the law of the member state. And the most important institution committing negative integration is, of course, the Court of Justice of the European Union. And since domestic collective labor law is traditionally based, and this is very well known to Italian scholars, on a triad of fundamental rights: freedom of association, right to collective bargaining, right to strike. Since it's so intertwined with these fundamental rights, Such a kind of intervention have proved to be much more shocking than other examples of negative integration. The other examples, of course, they were much more technical, and in fact, in other examples, like night work for women or the prohibition for women to work under the ground, in fact, elements of social law were attacked on the basis not so much of economic law, but on the basis of more or less social principles, like the non-discrimination based upon sex. Here we see that fundamental issues are being attacked on the basis of petty principles of EU economic law, not on the basis of other fundamental rights. Therefore, the Viking and Laval judgments have created the risk to alienate the most ardent supporters of European integration, the trade union movement, from that dynamic. And you don't have to be a Bolshevik to argue this. I am quoting Professor Monti here. He has said it. And it's not the Bolshevik, as far as I know. Nowadays, the risk is even more harsh, the risk of negative integration, due to the tendency of the Court of Justice to use the freedom to conduct a business to outlaw progressive implementation of minimum directives, which is normally allowed. We see that, in fact, the freedom to conduct a business has been used to justify forms of direct discrimination, which are erroneously qualified as indirect discrimination. And we see that the freedom of religion has been sacrificed on the altar of the freedom to conduct a business. This is not a critique, this is just an observation. We are in the Mancini room. I'm not going to criticize the Court of Justice of the European Union. Now, if we look at it, we can still say that the EU collective labor law, although it could be interpreted broadly, is a branch of law, or part of a branch of law, which is still episodic, unsystematic, and spasmodic, as Brian Percussion would say. And the question is why? Why is it so fragmentary? Well, the most obvious reason seems to be a lack of a competence of the European Union to engage in positive integration in the field of freedom of association, pay, strikes, and lockouts. And this amounts to a dangerous lack of checks and balances, where the Court of Justice is free to attack national labor law, collective labor law, dealing with these issues, without being hindered whatsoever with a potential reaction from the legislator. And in a civilized legal order, mindful of Montesquieu, such a situation would have forced the court to give proof of pudeur, of reluctance. But I have not seen signs of such reluctance. Furthermore, and this is another explanation of the fragmentary character of EU collective labor law, we should take into account that whereas issues of information and consultation can be regulated by qualified majority, unanimity is required in the field of representation and collective defense of the interests of workers, including, by the way, co-determination. Now, this dissociation between collective representation on the one hand and modes of worker involvement on the other hand is slightly problematic. In practice, it has amounted to an approach, to a practice of the EU legislature favoring indirect, fortunately indirect, representation, allowing the member states to define which actors could be seen as the workers' representatives. So, member states will define it by means of the renvoi, as we say in private international law. And the Court of Justice, but it's not always possible to separate these two issues. Representation on the one hand, and information and consultation on the other hand, because indeed, the Court of Justice has indicated that these directives do generate an obligation to ensure the institution of local workers' representatives. And as I already told you, some directives have introduced unprecedented bodies of workers' representation, like the Special Negotiating Body and the European Works Council. And last but not least, it is important to stress that the European Union, and this is fleshed out in Article 152, needs to take into account the diversity of national systems of industrial relations, which seems to invite the EU legislator to restrict to some degree harmonization. And more importantly than the way in which EU competences are formulated, there is, of course, the political willingness to shape EU labor law and collective labor law. In the 70s, EU labor law delivered results despite the paradigm of market integration, despite the condition of unanimity. Whereas in the Barroso administration, there was a very cautious approach to intervene at all. Although there was the qualified majority, there was another paradigm available. The present Commission, in my view, now I'm going to say something positive about the Commission, so don't quote me, is a bit more proactive, and in fact also uses the pillar of social rights to justify its interventions. Although there is no systematic policy to use the pillar to make like a systematic overview of all the interventions possible. This is what the Delors administration did when they came up with the social action program to implement, if you want, the Community Charter of Fundamental Social Rights of Workers. Even though, I'm closing, the mere recognition of the Charter does not extend EU competences, it is important to stress that the recognition of these three fundamental prerequisites of collective labor law occurred late in 2009. So we have a Leviathan with a lot of power, the European Union, which was established in 1957, and it took more than 50 years before a Bill of Rights was given to the citizens of Europe. In fact, the mere absence of these foundations of EU collective labor law, the freedom of association right, strike right, collective bargaining, has prompted Lofaro to challenge the idea that the precepts from the European social dialogue constituted genuine expressions of collective autonomy. The notion of collective autonomy is, of course, very well known in Italy for obvious reasons. Okay. And however, these foundations, they have now been laid down. They should be considered as fundamental principles. So this is an important evolution. Although I must regret that in the recent pillar on social rights, there is no reference at all to the freedom of association. Can you imagine that? There is no reference at all. And even when there is a reference to the right to bargain collectively, it is stated that the Commission has the right to censure, you could call it, collective agreements, to refuse to implement them on the basis of a appropriateness test, which is something which is very upsetting, I think, for the trade union movement. I can refer to, obviously, the Epps case. I also regret, since we are dealing today with digitalization, that in the draft platform work directive, there is no real right to information for those platform workers who are not considered to be workers in a state of subordination. If you take a right to information and consultation seriously as a fundamental right, you should have a broad concept of the worker. If not, you are depriving human beings from their human rights. As far as the evolution, last phrase, is concerned of EU collective labor law, I think we know from history that it takes a lot of time for social Europe to progress. And this is probably in the field of EU collective labor law due to extreme divergences, okay, between systems of industrial relations. And usually scholars speak about differences in culture. Now, I'm a student of history of art, and this has nothing to do with culture. This has to do with political history, economic and social history. Above all, it also depends the pace of the development from the political will of the EU Commission. And this political will always be a reflection of political convergences or divergences at the level of the member state. I have said what I needed to say, Professoressa. Thanks. Scusa, I will close my microphone.
Microphone.
Professoressa, we cannot hear you. Professoressa, we cannot hear you. Can you switch on your microphone? Perhaps she cannot hear me. Ah.
Però non lo sento neanche.
Prova a accendere il microfono e parlare.
Neanche da casa sentiamo.
Però sentiamo te, quindi non è un problema di radio.
Okay, Fiorella, if you try to exit probably and enter again, okay, so probably this could be sufficient. We wait for a moment and then if the problem persists, then we will move on with the first discussion. Okay, now. Yes, yes, we can hear. Thank you, Fiorella.
The microphone was on. I couldn't intervene. Thank you very much to Professor Dorsmont for his brilliant reconstruction of the status quo of the collective labor law in Europe, very suggestive reconstructions. And I appreciate too the remark about the lack of punctual and direct handbooks on collective labor law. That means, I think, that a real collective labor law, effective, a collective labor law that you can touch doesn't exist in Europe. And I appreciate too the reference to the importance of the principle of non-discrimination that, as is known, plays a structural role in Europe, both on economic and social level. So, thank you very much for your relation, your report. Now we come to the panel discussion. I follow the order of the panel and leave the floor to Leonardo Battista dell'Università di Bologna with a report about the European Framework Agreement on Digitalization, Challenges and Priorities. Please.
Thanks, Professor Leonardon, for the floor. And I would like also to thank Professor Pissoferrato and the organizers for the invitation. Moreover, I would like to thank our brilliant guest speaker, Philippe Dorsumont, saying that it's not very easy to talk after him, but I will try to do my best. However, the topic that has been assigned to me is the European Framework Agreement on Digitalization, talking about the challenges and the priorities of such agreements. This is an agreement that has been concluded in 2020, so it has a 3 years span of experience, but as we will see, there are many issues that are still on the floor. However, before starting my presentation, I would like to thank the European Trade Union Institute because they shared with me some internal material that were really useful for the implementation procedure and my presentation, also because more of them are still internal ones. However, before starting our process, we have to talk about the nature of such European Framework Agreement on Digitalization that is easy to understand, deals with the digitalization and the digital transition and the implementation of technology in the world of work. Normally, when we talk about digitalization, we talk about this catchword of the public debate, of the academic debate. Some call the digitalization a mega trend. However, it's important to stress the intervention of European social partners into such topic. This agreement was concluded, as I said, in 2020, covering a 4-year period from 2021 to 2024. And such period is important for the implementation, because as we will see, this agreement was concluded under Article 155 of the Treaty of the Functioning of the European Union by the European Trade Union Confederation and the employer association such as Business Europe, ESME United, and SG Europe. And one of the main issue of such agreement is its nature. This is a self-initiated and self-implemented collective agreements that, thanks to the Smithman's studies on social dialogue product, is named a CICICA collective agreement. What does it mean? It means that the implementation and the proposal of such agreement is only based on the intention of the European social partners. So it's not stemming or directly driven by any European Commission initiative or by any initiative of the European Parliament, nor requiring any implementation from the European institution. And we will see it can create some imbalances among countries that have a low level of trade unions. The aims are clear. The idea is to create opportunities for workers and employers to deal with digitalization and avoid any misuse of digitalization within the workplace. For example, we will see the issues regarding to the right of disconnection, the phenomenon of always available and always connected that can create some issues for workers. For example, reporting the threatening of workers that in a certain sense can have problems, say, that are not available to the employer. Another issues that this framework tries to aim is to avoid giving a set of specific operational directives to the national trade unions, also because there are a lot of differences between countries, for example, from the eastern part of the European Union and the western part of the European Union. And we will see that it's incredible that the countries from the eastern part of the European Union are the ones that are more involved in dealing with digitalization and try to avoid the misuse, the manipulation of data, the impact of the artificial intelligence. Before going to the implementation issue, because I decided to look at the implementation and the follow-up of this European Framework Agreement, we have to talk about the different challenges that the IFAD, as I will recall him, tries to underline. There are 4 different challenges. And the first one is the lack of digital skills and the idea of investing in upskilling and reskilling workers in order to secure employment and avoid unemployment led by the digital transition. Another topic is the modalities of connecting and disconnecting that we will see is a problem not only from the internal collective relations, but it's also a problem related to the European Union from a normative and legislative perception. Then other two principles and issues are regarding to the artificial intelligence and the respect of the human dignity regarding to the algorithmic surveillance that we have seen is one of the most important topic right now for those who are looking at the artificial intelligence. Because as also Professor Lunardon said at the beginning, we have to deal with the human in control principle. So granting that the decisions of the algorithms are driven and controlled by a human being in order to avoid biases or discriminations. In order to understand this joint dynamic circular process, as I call him, we have to think that the IFAD tries only to give some guidelines, not give some directives. And this is a real different perception of also the effectiveness, because if we give some guidelines, then the national or the sectorial social partners in different countries can decide which is the appropriate level and which are the appropriate measures to be adopted in order to implement the European Framework Agreement. The implementation procedure is based on a 3-year process with the final and joint report in 2024 by the European social partners. And as you will see, these are the internal documents that E2I kindly shared with me, saying that the 3rd report of 2023 is still pending. So we will look at the implementation process of 2021 and 2022, because normally the report is published in June. And in order to understand which are the real implementation experiences, I try to understand and conceptualize 4 different patterns of intervention. As I said, there are differences in the industrial system of industrial relation system of every country. So it is also different the level of implementation and the result that has been achieved. We have also to say that not all the EU 27 countries responded to the request for the yearly based report, and this is one of the main problem of the European social partners. And you just to think that, for example, France or the French social partners decided not to share any information to the public, and this is one of the main issues regarding the collaboration among national social partners. The 4 different partners regards the first one, seen as the partnership among national social partners in trying to implement nationally, depending on the level that has seen as the appropriate one, the management of the digital transition. Then the second partners regards the intervention and the involvement of public authorities in such process. Then we will see the third pattern that regards the individual initiative that every social partners decided to implement individually in the specific country. And then the fourth pattern regards the collaboration and the synergies among different national social partners. And this is one of the points that, in my opinion, is more interesting because it gives also the possibility to share the experiences. As we will see, the majority of the initiatives are driven by the digital skill issue regarding the upskilling and reskilling of workers in order to avoid the unemployment brought by the digitalization and the use of technologies, in the labor market and within the workplace. Then we will see the right of disconnect with the phenomenon, as I said, of always online and always available, and an embryonal attention to the challenges brought by the artificial intelligence. We have also to say that right now, also public authorities are still have not still clear in mind what is the artificial intelligence and which are the real challenges that are brought by it. This is a small table about the different countries. I try to look at every single national report, and I decided to give you some specific experiences. I will not talk about all of them. For example, for the first partner, about the partnership at national level among trade unions and employers association, in my opinion, one of the interesting pattern is the intervention in Netherlands. For example, we had a high emphasis on sectorial collective agreements to introduce provisions on digitalization, on digital skills, the provisions about e-learning courses in order to avoid that some jobs could be obsolete, so in order to avoid the so-called obsolescence of work. Or the Poland, where the Polish trade unions try to invest and finance a lot of courses in order to create new jobs. Or the tripartite initiatives with the involvement of the government or the public authorities. For example, Spain, with the digital skills training plan of 2020, that is still working, has the aim of training at least 500,000 workers in digital competencies in 4 years. And this is one of the highest intervention about Spain in digital competencies. Or the Austrian involvement in the promotion of the new home office legislation about remote work, with the idea of refunding utilities or imposing a voluntary agreement in order to avoid the misuse of remote working or digital work for workers. Then the third pattern, I will only talk about, for example, the Malta one or the Irish one, where Malta tried to invest for the Malta Chamber of Commerce, that is one of the employers' association, involving in the right to disconnect, creating courses for employers, and giving some specific documents for the employers in order to avoid, for example, to impact on the private and social life of the workers. Or the Irish initiatives that requested, the ECTU requested a meeting with the Irish government in order to stress the need to allocate at least the 20% of the National Resilience Plan funds to the digital transformation regarding trainings for workers or the creation of funded apprenticeship for young workers. Then the fourth pattern, that is the last one, regards the use of European funds, for example, the European social funds or other funds for social dialogue, in order to create collaboration among the countries. For example, the initiating activities to implement the IFAD, that is the second project, is led by Solidarność, the Polish trade union, and the CIS, and is very useful because they try to present and share to Romania, Lithuania, and also other countries that are partners the positive effects of the regulation that are trying to impose on the right of disconnect in some specific sectorial agreements. Lastly, I would like to conclude saying that it's obvious that the pandemic from 2020, right now, we can say, creates some problems on the implementation of the European Framework Agreement. It creates some problems, but is also stressed and boosts the use of digital tools. We cannot say that remote working is a new topic, because we know that during pandemic it was very useful. However, we have also to say that the use of remote work create also an issue about the imbalance and unbalanced, we could say, intervention of the national social partners on the right of disconnect. In fact, in many of the reports that I had the possibility to read, there was the request to a supranational regulation at EU level in the field of right of disconnect. So we could say that the HEFAD highlighted the needs, but it has not the enough powers to implement this kind of right for workers. However, and this is a short circuit that is creating huge problem. This is the last things that I'm going to say. Even if the IFAD is dealing with the right of disconnect, and even if we, as I said, there are still some problems on the intervention of national partners to deal with the right of disconnect, there is a problem that has been created by the European Parliament with the resolution of January 2021 on the right of disconnect, that is imposing a stop, a political restraint for the European Commission to take any action on the right of disconnect, because there is the IFAD that is still in charge of this kind of intervention. And this is a problem because even European social partners are contesting such stoppage from the European Parliament, saying that it's needed an intervention of the European Commission, and it's needed a collaboration. So this is an unwanted short circuit that is undermining right now the IFAD. This is the last slide. I would like to thank the audience, and I would like to thank also those who are here looking at our brilliant discussion.
Thank you. Do you hear me?
Yeah.
Thank you for your punctual and interesting observations about the content and role played by this European Framework Agreement. Now, we have in the panel Giulio Centamore dell'Università di Bologna with a report about the involvement of social partners in the design and the implementation of the recovery plan. The floor is to Giulio Centamore. Please.
Thanks, Professor Lunardon. Good morning, everyone, and thanks also to Professor Pizzoferrato for organizing this seminar and for the invitation. I'm very glad to be here and to take part in today's discussion. And thanks also to Professor Dorsmont for his brilliant presentation this morning. So I do have PowerPoint presentation too, and I'm going to share it with you now. Just give me a moment, please. Okay, so you should be able to see my presentation. Okay. So my topic today will be the involvement of social partners in the design and implementation of the Recovery and Resilience Plan. That is to say that I'm going to talk about tripartite social dialogue in the context of Next Generation EU, of the stimulus package, Next Generation EU, which is a temporary financial instrument of exceptional nature that aims to help member states recovering from the social and economic crisis caused by the COVID-19 pandemic, but also, on the other hand, to foster both at the member state level and at the European level the so-called twin transition, the green transition and the digital transition, the two great transformations of our generation, which are happening at the same time, are deeply intertwined, as we know, and need to communicate each other. Member states, in order to have access to the grants and loans funded by the Recovery and Resilience Facility, basically have to prepare and submit to the EU Commission a Recovery and Resilience Plan, which is basically a package of reforms and investment projects aiming at dealing with the twin transition and the recovering from the pandemic. So all European member states, all EU member states did prepare and submit their plans to the EU Commission, basically in 2021-2022, and the Resilience and Recovery Facility is currently supporting them financially. The Hungarian case was a little bit more problematic than the others, but actually it was not for technical reasons related to the plan, to the program, but for political reasons, let's say. So I'm not really going to deal with it. My second slide. As you can see from this slide, the Recovery and Resilience Facility doesn't have and won't have the same weight, the same impact in all EU member states. In particular, this graph shows the recovery allocations as a share of GDP in the 27 EU member states. What we can see from this slide is that in some member states, such as Luxembourg or some other Nordic country, the recovery facility is not expected to have a huge and important financial impact and social impact, economic impact too. Social partners may have different priorities than being involved in the design and implementation of the recovery plan. However, in many other member states, and perhaps for the EU itself, for the EU as a whole, the recovery plan is considered to be a once-in-a-generation chance to strengthen the economic system and the social system. And this is, of course, the case of Italy, as you can see, and hence it is not surprising that the whole issue of the recovery is always very well covered by the media, is one of the key points in the debate between the government led by Giorgia Meloni and the opposition parties, and it is also very high on the agenda of the social partners. So let me give you an easy, quick demonstration of this. The three main Italian trade unions, CGIL, CISL, UIL, or CGL, CIS, and WIL, since we are in Bologna, recently launched a joint mobilization, and this is actually already good news because they are not always on the same page. And they also published a common document, a joint document, for a new era of labor and rights, as you can see from this slide. So one of the key points in this document is actually, as you can see, and I'm quoting from the document itself, that they are asking the government to take the actions necessary to carry out the investment and reforms envisaged in the National Recovery and Resilience Plan, strengthening a participatory governance model that sees the joint action of the government, regions, local authorities, and social partners to implement the projects and to encourage the actual and effective spending of the resources envisaged. So, this is the case in Italy, but also in other European member states, and there are no doubts that here it is very high on the agenda of the social partner. But in the next slide, I'm going to ask to focus the attention, to draw the attention on why should national governments, national lawmakers involve the social partners in the design and implementation of this project, of this plan, which is supposed to reshape the future of Europe, as President Ursula von der Leyen herself has said many times. So I think there are, among others, two main arguments for that being the case, for involving the social partners. And the first argument is that of legitimation. Of course, in all EU member states, we do have democratically elected institutions which are in charge of and are responsible for the use of public money. And this is true, of course, also when it comes to the grants and loans funded by the Recovery and Resilience Facility. However, since this plan is expected to impact on the life of millions of European workers and hundreds of thousands of European employers, it is a very basic principle of justice that strongly suggests to take into consideration their opinion, the opinion of the workers and of the employers too. Of course, not directly, but through the representative associations, trade unions, and employers' organizations. So basically, social dialogue and tripartite social dialogue too enriches the quality of representative democracy. A second argument might be that of an efficient complication. I'd like to call it an efficient complication of the political process. So, if taken seriously, the consultation involving the social partners, of course, does and will slow down the work of the institutions. Since they will have to share information and documents, they will have to prepare and send one or more drafts, they will have to discuss maybe this draft with social partners. They are supposed to listen to what social partners would like to say. They might receive comments, even critics, and so on and so forth. So the consultation will definitely slow down the legislative procedures, the political process. But it is also true that at the end of the day, the institutions are supposed to come up with better solutions, better ideas, better projects. And this for many reasons. One of these reasons might be that social partners may provide governments and lawmakers with the technical knowledge that is always needed in order to intervene in specific sector of the economy, in specific parts of the labor market, and so on and so forth. And then we should not forget that at the end of the day, workers and employers are the very same actors that are going to implement, to put into action the recovery plan, the measures decided in the recovery plan. So it is perhaps for these reasons or for similar reasons that Article 18, number 4, letter Q of the EU regulation establishing the Recovery and Resilience Facility establishes that member states should take into consideration the opinion of social partners. How? Number 1 of the Article 18 establishes that a member state wishing to receive a financial contribution shall submit to the EU Commission a recovery plan. And this plan shall, and so on, then in particular set out the following elements. According to the letter Q, the recovery plan has to set out for the preparation and where available for the implementation of the recovery and resilience plan, a summary of the consultation process conducted in accordance with the national legal framework of local and regional authorities, social partners, civil society organizations, youth organizations, and other relevant stakeholders, and how the input of the stakeholders is reflected in the recovery plan. So basically, I think there are two main obligations on member states. The first one, of course, is to set up, to organize the consultation itself. A consultation has to exist, has to be carried out. But the second one is reporting to the EU Commission in a specific chapter of the recovery plan with a summary. And in this summary, the member state is supposed to point out also how the input of the stakeholders is reflected in the recovery plan. So this may be important. This might have some importance. Of course, Article 18 does raise many questions, several issues. I don't have the time to deal with it thoroughly, but let me touch on a couple of points in the next slides. So, member states are supposed to carry out, to conduct the consultation process in accordance with the national legal framework. So this basically means that there may be a variety of consultation mechanisms and tools, and this is fine, of course, since, as we know, social dialogue is not the same thing in Sweden of what it is in Spain, and it is not the same thing of what it is in Italy, in Poland, and so on and so forth. So, how to conduct this consultation process, how to involve the social partner according to Article 18. Let's take a look at what happened in the last 2 or 3 years. So member state might decide to set up, to organize 1 or more meetings with the social partners and other relevant stakeholders. These meetings might be in person or might be virtual meetings, online meetings. This was the case in Austria in 2021, but also in other EU member states, basically and mainly because of the COVID restrictions that were into force in 2021. But this might also in the future may be the case because of extreme meteorological events caused by or exacerbated by climate change. Poland, for instance, the Polish government published an online website, created and published an internet platform in order to share information with the social partners and other relevant stakeholders, maybe also to receive comments from them, but this is actually less clear. There can be, or maybe, a variety of forms, of tools, of mechanisms. So Portugal, for instance, used an existing tripartite body in order to carry out the consultation process, while in France, a specific committee for the monitoring of the recovery plan was created. And this is more or less the same case in Italy, where the Mario Draghi government created a consultation forum involving all the relevant stakeholders. So a variety of tools and mechanisms, and this is fine. This is perfectly fine, because we have a variety of industrial relations systems and cultures in Europe. But my last point is, does Article 18 at least require member states to carry out a timely, genuine and meaningful consultation, or does Article 18 only require to carry out a consultation whatsoever? Let me give you a quick example, a quick demonstration of it, or something to think about. And I'll quote from a recent and very good Eurofound report, precisely dedicated to the involvement of the social partners in the design and implementation of the recovery plan. And a case from France, an example from France, the Eurofound correspondent reported this case, this episode, this situation, quoting from a trade unionist from CGT, one of the main French trade union, as you know. So the government, in that case, in that situation, organized a consultation meeting. And I'm quoting, a first 2-hour meeting with a presentation of a first draft of the national plan with 8 peak-level organizations, which means there was only time for a few remarks. Then there was a second 2-hour meeting where you received 800 pages a week beforehand. How could we deal with that at CGT? You would need a very good AI maybe to analyze in 1 week 800 pages and then being consulted, make comments, critics, and so on and so forth. Germany, second example. The German trade union DGB reported that the government gave only 3 to 4 days in order to deliver written comments on the draft of national plans. There are these 2 examples, but there could be many other. But last point, I was wondering, what do we have in Article 18 that would push member states to seriously engage in the consultation process, to take it seriously? Actually, not much, of course. But let's concentrate for a moment on the last part of the provision. The recovery, the resilience and recovery plan shall, and so on, set out, and so on, a summary of the consultation process and how the input of the stakeholders is reflected in the recovery and resilience plan. So, this might be read at least in 2 different ways, in my opinion. The first one might be that member states will comply with Article 18 as long as they are transparent in reporting to the EU Commission about the consultation process. So we organized one or more meetings, we published an online platform, we received comments, or maybe we didn't receive comments, but this is not our problem. So only a sort of transparency here. All member states actually have a chapter on the consultation process, and maybe even if the time allotted was not too much, even if the information were not shared in an appropriate way, it doesn't matter. So only transparency here. But a second, there is a second option, and according to Article 18, since member states, this is basically the argument, since member states have to point out to the EU Commission, have to indicate to the EU Commission how the input of the stakeholders is reflected in the recovery plan, this might mean, this might imply that member states have also an obligation to put social partners and other stakeholders in the condition to actually engage with them, actually engage with the government and take part genuinely in the consultation process. And last remark, this maybe might also be consistent with the employment guidelines of the Commission and the Council. The employment guidelines mainly operate in the context of the European semester, as we know, but also the reporting of the recovery plan operate now in the context of the European semester. So it is maybe possible to use these employment guidelines, which actually, and here I'm thinking about the number 7 on social dialogue and labor market, member states are asked, have an obligation or are asked to involve, to consult social partner in a timely and meaningful way. So this would be consistent with this second opinion. Of course, this is a tiny little thing because then the governments and the lawmakers are in charge of and are responsible for the drafting, the designing and the implementation of the recovery plan, but at least we might suggest to have a real, serious consultation process. Thanks for the attention.
Thanks, Sue, for your accurate description of the different ways of involvement of social partners in this very complicated task. This very complicated task. I may say that there is a push toward the triangulation of the tables of debate, without forgetting the role, obviously, of workers and enterprises. But now we have it's the turn of Chiara Garbuglio, University of Venice, Venezia, that will entertain us about digitalization, labor market, and collective bargaining. The floor to you.
Thank you, Professor Lunardon. And I don't know if I can move PowerPoint presentation, but it's not a big deal. Matteo, maybe you can share to the students if you want my presentation, because I don't know if I can. No. Okay. No slide, no PowerPoint presentation for me. So thank you, Professor Lunardon, and thank you, Professor Pizzoferrato, for inviting me to this panel. Thank you, Professor Dorsemont, for his lecture. And I would like also to express my solidarity to the colleagues of Bologna and Emilia-Romagna in this critical moment. Now, I move to my speech. Digitalization has evident impacts on the employment relationship. Scholars underline the effects on the work despatialization, because work can be performed everywhere, is not linked to a specific workplace. And on work detemporalization, from a work performed in presence for a certain period of time to work by objectives. But the title of my speech led me to consider not only the individual dimension of the employment relations, but especially what we can find outside the company's boundaries, that is the dynamics that characterize the current labor market. So I will analyze the link between digitalization and labor market, namely the effect on of digitalization on labor market, on the needs of companies and employees. Then I will analyze the relation between labor market and collective bargaining, that is, what role can play collective bargaining in order to maximize the chance offered by digitalization and to minimize risks and criticism that digitalization causes. Labor market represents a playground for digital issue due to the fact that digitalization affected in different ways. It has been changing the methods of works, and it requires new jobs and skills. For these reasons, digitalization has been transforming the way labor market function, with opportunity and risks that have to be considered and solved. Digitalization has changed the way of performing working activity, and these affect the labor market. For instance, remote work is now considered by employers and employees as a new norm. In Europe, there is an increase in demand for remote working from employees and also from job seekers. It can represent a tool for inclusion of vulnerable categories of workers, as people with disabilities, but also for women, a measure to increase their participation in the labor market. After pandemic, phenomena such as Great Resignation show us that employees desire a better work-life balance and in many cases refuse jobs without hybrid and digital work arrangements. So companies are redesigning their workplaces to accommodate hybrid and flexible work arrangements in order to avoid job vacancies remain unfilled because employees cannot find the flexibility expected. But now I would like to focus on the relationship between digitalization and content of jobs. Digitalization refers and includes a variety of jobs which require different and heterogeneous levels of skills. The adoption of new technologies for products and services will increase new jobs in many sectors, but low-skilled workers in manufacturing, in basic clerical workers could lose their jobs due to the automation and digitization of a large number of their tasks. Think about services sector, online retail, or banking activity. skills required, that is the content of job, are crucial to allow workers to remain in the labor market. Labor market require more advanced digital skills, but there is a shortage of digitally skilled workers and a high level of skill mismatch. New skills are needed for emerging jobs or tasks, but nowadays more than 70% of employees in EU need at least basic IT skills to satisfy job demands, and about 30% of them are at risk of falling into the digital skill gap. Also, European Commission underlined that over 70% of companies have said that the lack of human resources with adequate digital skills is an obstacle to investments. Digital age requires skill related not only to digital competences such as data analytic ones, but also to social, emotional and soft skills such as creativity, critical thinking, decision making, communication. And those skills are fundamental to adapting job profiles, workplaces and work organizations to the digital transformation. We also assist to the digital skill mismatch. Many workers in the EU consider that their skills are underused. In some cases, graduates feel that they are overqualified for their job. But around 40% of employees would need reskilling to be prepared for its current job. So digitalization offers a huge range of labor market opportunities for higher skilled workers and workers capable of adapting to new skills needs. Low-skilled workers are at risk of losing their job, and they need to manage the transition to the digital age. The crucial point is if workers are prepared to manage a professional transition and if educational path can provide the required skills on time. This is a challenge not only for employer and employees, but also for institutions and namely for collective bargaining. So what is the role of collective bargaining in the current labor market? What can collective bargaining do to help workers to the technological transition? How it can support them toward an inclusive technological environment? If digital skills are crucial, education systems has to anticipate future skills needs and adapt curricula to provide the required content. This goal has to be pursued jointly with the businesses, sectors and institutions, but the role of the social partners and collective bargaining is fundamental to facilitate this process. Collective bargaining can monitor future skill needs, encouraging lifelong learning among the human resources, and providing financial and other kind of support for training to workers and employers. For example, the National Collective Agreement of the Mechanical Industry in Italy, renewed in 2021, includes a specific article, the Article 7. This article is devoted to the lifelong vocational training as a right for every employee. This article underlines the importance of digital skills to be to bridge the gap between competences of employees and skills required by new organizational and technological models. This article aims to build a digital identity of the employees through the individual project. It also underlined the importance importance of soft skills to increase the enterprise competitiveness. And this kind of article represent a positive example of collective bargaining, careful to present need of companies and workers. Collective bargaining can also participate in linking education system and businesses. Think about apprenticeship contract. This contract required the employer to provide the worker not only with salary, but also with training, and represent a useful legal tool to link educational path to labor market. It aims to create a specific professional identity to the employee. In the Italian system, collective bargaining plays a crucial role in the definition of the vocational training during this kind of contract. It defines in every productive sector the duration and the modality of training. I think that the use of this tool should be implemented. It is an important bridge between education system and the labor market, and collective bargaining has to actively participate in the training definition to avoid mismatch and digital and soft skill gaps, in particular of the youth people. So to sum up, digitalization is changing labor market and structural demand for skills. Digitalization allows employees to desire and use remote work to achieve more flexibility, to do new jobs, but required proper training and skills. Upskilling and reskilling of the employees play a central role in meeting the labor demand of new sectors, including also vulnerable categories and avoiding skill mismatch. And collective bargaining, as Leonardo has underlined in the first speech, is fundamental to support employees and employers in the digital transition, also in connection with educational and training systems. I think that in the light of these strategies, we have to consider digitalization as a part of a wider purpose that is to achieve a more digital and greener EU economy. In this sense, digitalization represents a crucial and autonomous challenge, but also a vector to implement climate policies. For this reason, in 2020, the European Commission launched the so-called Pact for Skills as a main action of EU skill agenda to improve and develop training system across Europe. The Pact supports public and private organizations with upskilling and reskilling to face with green and digital transition. The Pact put together national and local authorities, social partners, and cross-industry and sectoral organizations to building skill partnership, monitoring skill supply demand in the labor market, and anticipating skills needs. In conclusion, I think that the Pact could be a great chance for collective bargaining to play a crucial role and to support workers and employers towards a green and digital age. Thank you.
Thank you. Thank you very much to you. And I thought that after digitalization, the world won't be the same. And I began thinking in this way since the terrible lockdown we lived during the pandemic period. So, very interesting, your observations. And also the remarks about the importance of the smart work and so on. we now have in our panel Davide Tardivo, University of Padova, that will speak about national collective bargaining and digitalization, first empirical evidence. Please, I leave the floor to the speaker. Thank you.
So, thank you very much. Can you hear me? Okay. So thank you very much for the invitation to Professor Pizzoferrato, Professor Isabel Nardon, and Professor Dusermont, and to all the other speakers for having me here. I want to go straight to the point of my presentation, and I'm very happy to talk just after Chiara and Leonardo, because my presentation will try to integrate from a national perspective what they try to talk about in their speeches. So the title of my presentation is strictly related to the role of national collective agreements in the regulation of digitalization. So when we talk about national collective agreements, we are talking about a precise method and a precise technique, because this implies that social partner, national collective agreement, imply that a social partner just don't want to be a mere spectator or a mere watchdog, a controller of the employer when he introduces in the plant digital instruments and tools, but social partners wants to be an
Fiorella, can you hear us?
Yes, yes, I can hear you.
Okay,
But
we missed Davide, unfortunately. So, Davide, can you hear us? This is technological problems.
By the way.
No, by the way, probably we, yes, by the way.
Technological problems.
No, I think also because of the timing, I don't know if it could be better to move on with the next. No, okay, Davide is coming again. Okay.
Can you hear?
Yes, now yes, thank you.
Okay, I'm sorry. So I will try to okay.
David is back. He's back.
Okay. I'm sorry for the problem. So I was talking about the precise purpose that our social parties had and assumed when they decided to be a partner in the determination of the rules that govern the digitalization in the workplace. Preliminarily, I tried to ask myself, just as Chiara said, did the trade unions in Italy embrace the challenge of digitalization? So looking at the main collective agreements at national level, we can say yes. So our trade unions decided to participate in the definition of the rules. Of course, in some sector more than others. For instance, the manufacturing sector is the most responsive one to the digitalization, more than, for instance, service sector. But as we will see, also some other collective agreements try to go in deep in this regulation. I will try to give you a sort of overview, starting and trying to divide the possible topics related to digitalization in which trade unions intervene. So I've tried to define three areas. The first one is the area in which national collective agreements already introduced a specific and deep regulation. The second one is an area in which collective agreements introduces some provisions, but I think there is still a room to other and more analytical interventions. And then the third one is an area in which I think we will not see an effective and analytical regulation at national level, but national collective agreements can operate as tools of indirect regulation. So, for instance, the first area in which national collective agreements already intervene are related, for instance, with training, just to integrate what Chiara said before, education and training, and the job description. National collective agreement in the metalworking sector before 2016 and then 2021 at Article 6 and 7 introduced and changed the perspective of collective agreements in the field of education and training. This agreement introduced a subjective right to training 8 hours per year, and this agreement has been followed by other agreements, for instance, the eyewear sector of 2023 and the goldsmithing sector, metalworking small and medium enterprises, both 2017. I think this agreement, the metalworking sector agreement, introduced also a noteworthy innovation, which is the principle of a sort of, I can define it, training by design. So the creation of national, local, and national and local commission, and also in productive units with more than 300 employees, a representative of the employees for training, and all these bodies are entitled to collect the needs, the effective needs of training of the specific workforce. So we are not talking about general schemes of education, but we have bodies which are devoted to collect the specific needs of that workforce, and then they define the training path that that workforce must follow. Also in the service sector and the metalworking sector, we have an innovation in job description, for instance. Metalworking sector agreement for the industry, we had a revolution in the job description. So now we do not have the list with the example of the jobs that we can find in the plant, but we have description based, not the description of the role based not only on the previous criteria, autonomy and technical skills, but we can find now cross-sectoral skills, permanent improvement, versatility, polyfunctionality. So all these criteria concur to define the role that now we can find in the job description in metalworking agreement of 2021. Then also in the service sector, which usually is not so responsive to innovation, we can find specific provision, Article 115, for companies operating in the information and the communication technologies, which introduce a classification of employee based on the ESF index, the E-Competence Framework Index. So in order to help companies to describe these new jobs, these new skills that the digital transformation introduced in the productive process. Also noteworthy is the procedure of the National Collective Agreement in the service sector to update job description even before the term of expiration of the contract, in order to ensure the adaptation and the adjustment of the description of jobs in this particular field. So in this area, I think national collective agreements already played a role, an important role. Of course, not all collective agreements, not in all sector, but I think we can find out positive evidences here. In another area, in the second area, I think for some regulation, national collective agreements can already play an important role. For instance, the exercise of trade unions' right. Many contracts that I analyzed regulate trade unions' right and in rights of employees, likewise the electronic bulletin board or the possibility to have an assembly of the trade unions in hybrid mode only for remote workers. For instance, the banking sector agreement of 2019, the wood sector agreement 2021, energy and oil sector 2022, and telecommunication contract at national level. All these agreements so reserve this kind of rights of trade unions only for remote workers. So why not for all the employees, not only for remote employees? And I think in this area, for instance, if we look at the metalworking agreement, where we have a provision which obliges the employer to provide the trade unions representatives the hardware, a personal computer, but not the software. So I think, for instance, Zoom or Teams, just to provide and have the possibility to hold an assembly in a hybrid model or a remote model, online model. I think that collective agreements here have to specify, as well as they have to intervene, as Leonardo said in the opening of our panel, in the right to disconnect. I tried to look the collective agreements at national level here, many of them, so we have an ambiguous definition. For instance, the field of application. Many of the contracts reserve the right to disconnect to remote workers only. For instance, the National Agreement of Metalworking Sector. Others extend this right, as I think it is correct, to all workers. For instance, the Electricity Sector Agreement 2022 or the Gas and Water Agreement 2022. The content, even here we have problems. Many contracts defer to company agreements, the decision to define what is the content of this right, what this connection means. For instance, the culture sector, the metalworking cooperative sector agreement, and then energy and oil agreement. All these agreements at national level are of 2022. Other contracts did not even mention the right to disconnection, even recent one, the service sector agreement, for instance. I think that noteworthy are some of the minor, we can say, collective agreements at national level, which go more in deep. For instance, the embassies, employees sector national agreement and the credit and insurances sector agreement, both of 2022, define what we could how we should define the right to disconnect, the right to do not answer, read messages, emails, and calls outside the working time. But I think that still here, a national collective agreement should play a more important role here, especially in terms of defining the content, and not only to defer to company levels agreement, this kind of decision, which are common of all the category of the employees in that sector, but we could say in the world of work, which is in the same situation. And this led me to go to the final area in which I think we do not see so in the next future a regulation at the national level. I've tried to find out, for instance, if some national collective agreements introduced some provision in the algorithmic management field or in complex procedures of personal data processing. I did not find any provision. I found out an agreement at local level in the province of Cuneo, which regulates the introduction of the algorithmic tools in the workplace. But at national level, I think that national agreements cannot have a real role in the definition, in direct definition of this discipline in these fields. So why? Because the algorithms and the procedure of personal data processing are so embodied in tools, softwares, very much complex and whose transformation is very fast. So I think, and in addition, on the other side, so in addition, if we decide to defer to company level agreements, the discipline of this kind of tools, we have still a problem, because representatives of employees at the local level usually do not know how these tools work. Okay, it is very difficult. We have seen this in the for judges. Just in the case of the platform worker, it is difficult for judges they have experts to understand how an algorithmic tools works, how personal data protection processes and data protection processes work. So at company level, I think it is correct just to involve the company level, but we need a structure and a body, as we have seen for the education and training, where trade unions and national collective agreements create local, national, and company bodies and commissions to support the action of employees representative. I think that in this field, in these specific fields, national collective agreements should play a role of indirect regulators. They should provide, for instance, commission of experts to the representatives of employee at local level. And then, because if we want to rule a phenomenon, we must know it. If we do not know it, we cannot rule it in an effective way. So just to do this, and I will finish here my presentation. If there are other questions, of course, I'm available to answer and to discuss. I'm sorry again for the problem of connection.
Thank you. Do you hear me? Yes. Thank you for your careful and specific overview on national collective agreements in the subject. And I see that Yes, I see that the metal workers collective agreement is always metal worker collective agreement is always in the forefront of innovation, as we heard. Well, now we have the presentation of Matteo Turin, University di Bologna, about industrial relations and new technologies, conflict, participation and communication in the digital network era. I leave the floor to Matteo Turin.
Thank you, Professoressa, and thanks to Professor Pizzoferrato for this opportunity.
Matteo, forse non si sente.
Can you hear me?
Yes.
Yes.
I have a short presentation. My speech will focus on the relationship between digital technologies and industrial relations. Well, the increasing use of digital technologies in work performance may constitute both a source of conflict and an opportunity for dialogue and collaboration for the social partners. In fact, from the effects on employment and working conditions of the technological organization of work arise several challenges for employers and trade unions. From these challenges may arise opportunity for dialogue, but at the same time reasons for conflicts between employers and trade unions. And that's why it can be said that the relationship between new technologies and collective labor relations is an ambivalent one, pushing the social partners towards two opposing and alternative models of industrial relations, a conflictual one and a cooperative one. Let's start with the conflictual model of industrial relations. Well, the use of new technologies in the performance of work activities may have consequences on the reasons for protest, as well as on the forms of collective conflict. On one hand, the effects of the diffusion of increasingly sophisticated digital technologies on the overall quality of working conditions and employment levels may represent a reason for mobilization and for outright conflict between employers and unions. Let's think, for example, to algorithms or wearable devices and their effects on employees' dignity, health, and safety, as well as on their working times and workloads. On the other hand, workers today tend to use more frequently the same IT tools used by companies to organize work in order to organize protests and strikes, and thus protecting their working conditions. Evidence of this trend may be the net strike or the so-called Twitter storm, which are two forms of union struggle on the web that have the advantage of involving, in addition to employees, users and consumers, causing the company towards the protest is directed reputational damage and thus exacerbating conflict. Moreover, gig economy has cleared the way for so-called strategic litigation. It has the recourse to the courts by trade unions as an alternative to strike and court action by employees. Why is this relevant? Well, because recourse to the courts as an instrument of self-defense and conflict resolution is an indication of the social partners' difficulty in establishing solid and lasting relations. So it is not surprising that strategic litigation has found fertile ground in digital economy and more precisely in the context of platform economy, which is a context of strained relations between employers and trade unions. So, to summarize, it cannot be denied that the digitalization of the economy and especially the need to adapt the organization of work to technological innovation, as well as its impact on employment and the quality of working conditions, represent two elements that facilitate the emergence of conflict between companies and trade unions. But is conflict the only possible answer? Conflict is not the only answer to the great challenges affecting the world of work, affecting labor law and work organization. It is well known that even in the persistent opposition of their respective interests, companies and trade unions can equally share medium and long-term development goals. So, for this reason, it cannot be ruled out that the actors of industrial relations, instead of adopting antagonistic behavior, which is often unproductive, decide to cooperate and find shared solutions to the problems posed by the need to adapt company organization to digital technologies and to technological innovation. Two examples of this trend may be the European Framework Agreement on Digitalization and the so-called Pact for the Factory of 2018. Leonardo has already explained us the contents of the European Framework Agreement on Digitalization. So I would like only to stress the fact that this agreement bets precisely on collaboration between social partners to overcome the challenges posed by digital transition to work organization and labor law and labor relations. A similar approach characterizes also the so-called Pact for the Factory, which relies on the empowerment of the social partners and their mutual collaboration to face the challenges posed to the Italian industrial system by digital transition, helping companies in this transition while at the same time safeguarding workers' rights and the quality of working conditions. Moreover, it is important to observe that the introduction of new technologies within the organization of work and their interaction with workers and employees may affect unions' priorities and strategies of action and claims. In fact, in a context in which technologies assume such a significant weight in defining work organization and therefore working conditions, their introduction and their use cannot be left entirely to the discretion of the employer. So it seems fair to expect that trade unions will struggle to make technological organization of work and the introduction of digital technologies in the workplace a subject of collective bargaining or even of co-determination. Regarding this topic, in fact, it is well known, it has been demonstrated that the introduction of new technologies requires to be effective the adoption of participatory models of relations between companies, trade unions, and employees. So, despite being a source of conflict, at the same time, technological innovation requires to strengthen collective bargaining and participation tools, pushing social partners towards a more collaborative model of industrial relations. In conclusion, which are the future perspectives? The outcome of the interaction between new technologies and collective labor relations is not predictable. As I said before, the relationship between industrial relations and new technologies is an ambivalent one. The introduction of new technologies and digital technologies in the workplace may be at the same time a source of conflict and an opportunity for dialogue and collaboration. We can observe that despite being called upon to adopt cooperative behavior to cope with the digital transition in the best way, the social partners are struggling to embark on a serious path of renewal that would lead them towards a more collaborative model of industrial relations. And this is particularly true for the Italian social partners, which are trying but are struggling to abandon a conflictual model of industrial relations. Anyway, in conclusion, I would like to be positive and affirm that the most likely scenario for the future seems to be that of a collaborative model of industrial relations. It seems to be only a matter of time. Thank you for your attention.
Thank you. Thank you to you for having underlined the ambiguous role of new technologies. The danger, I think, is the possibility of I don't know if I can use this word, the possibility of a disintermediation. In Italy, we say appunto disintermediazione between people and its needs and the trade unions, because trade unions, I always think, can win the challenge, but they can also lose. We don't know, but we must be optimistic, as says Matteo Turin. Well, now we can open the debate. So if there is any question, or if someone wants to participate, please, I leave the floor to the participants. No one? No questions? Well, if we think that we are done, I call Emanuele Menegatti, University di Bologna, that for for the closing remarks of this morning. Emanuele, please, I leave the floor. I leave the floor to you.
Thank you very much, Fiorella. I'm here. Well, it has been very interesting seminar with a lot of interesting presentation. I've personally learned a lot, starting from the very clear introduction made by Professor Fiorello Nardon, who pointed out the challenges posed, especially by digitalization, to social partners. But after Fiorello's introduction, then I must say that the fil rouge of all the presentations, including the keynote speech by Philippe Dorsemont, involve, say, a bit of disappointment and sadness, looking at the state of art of collective labor law, both at EU level and at the national level, as for the not only as for the challenges posed by recovery plans and digitalization, but in general. Philippe drafted a very clear picture about the, in matter of fact, non-existence of a comprehensive collective labor law, EU collective labor law, neither as a part of the legal order and nor as an academic discipline. However, the patchwork that we have at the moment has had some impacts on national labor law, as on the two sides, as positive harmonization, which has been slowed down because of the huge gap we have among national industrial relations. So we have these huge differences among the industrial relations in the member states. And also because of the lack of competence of the unions on the European Union on very key areas as for industrial relations, such as the right of association, wages, strikes, lockdowns. So it's quite inevitable that we have this very slow action carried on by the European Union, but especially because of the negative harmonization, which has been very clear in the mentioned Laval and Viking case. And so we have this, let's say, rather incomplete EU collective labor law. However, as Philippe said, it takes time, and the union is slowly moving forward also on the collective dimension of labor law. And perhaps the directive on adequate wages in the union is a step forward. And maybe, if approved, the directive on platform workers could be a new step toward the creation of, say, a more complete scenario as for collective labor law. Then we move to the speeches made by the young colleagues we had here today, starting from Leonardo Battista, who highlighted an example, a good example of a product of the European Social Dialogue, so the Framework Agreement on Digitalization, which, however, has had so far, as Leonardo clearly explained, a very weak impact on on the member states, and also which may lead us to assume that the agreement has a very weak effectiveness as for the impact on the member states. The reports which the national social partners as supposed to prepare for the EU have not been delivered by all the national social partners, and these again highlight the weakness of the weak effectiveness of the agreement, which has not perhaps been taken very seriously by all the national social partners. So again, we had the impression on how difficult is to promote an harmonization in the field of industrial relations at the European level. Then we had Giulio Centamore, who addressed the recovery and resilience facilities, which again could have been a good opportunity for the involvement of social partners, especially in the implementation of perhaps the most ambitious and expensive policy ever made by the European Union. And also Giulio pointed out the importance of the social dialogue in the framework of the implementation of the Next Generation EU under two aspects, triggering a more democratic process as for the implementation of the recovery and resilience facilities, and also for getting good advice as for the projects that can be implemented within the national recovery plans. And this is also, I mean, the opportunity of the involvement or even the necessity of the involvement of the national social partners and the social dialogue is provided by the regulation 241 of 2021 establishing the recovery and resilience facilities, as Giulio pointed out very clearly again. But also the scenario that we had from the Giulio presentation, even though the legal framework of the RRFF is rather clear on the involvement of the social partners, at the national level, very little has been done to involve the social partner. I think that the examples you provided from the Eurofond report about France and Germany and how little time has been given to the social partners to participate in the process is a very good example, a very clear example on how little are the member states interested in listening to the social partners. Then Chiara Garbuglio pointed out the looming threat that artificial intelligence and robotics, the looming threat of artificial intelligence and robotics hanging over us when considering the impact of digitalization on the labor market. She mentioned the labor displacement and labor transformation that the digital revolution is involving, and the outcome of these skills mismatch, which may involve a redundancy of workers and even a suboptimal use of many workers, which will have for sure a negative impact on productivity and also on worker satisfaction, as it has been confirmed by the surveys that Chiara has mentioned on involving European workers. So moving to the role of collective bargaining in addressing the challenges that digitalization is bringing on labor markets, she mentioned the important role that collective agreements can play as for lifelong learning and apprentices programs, and the role that collective bargaining has here, especially when referred to the Italian case, in the definition of vocational training programs aimed at bridging the gap between the skills we have nowadays and the skills we are supposed to have in as to cope with the digital revolution. So social partners can do a lot in bridging this gap, for sure. But again, looking at what is taking place currently, we have to be quite skeptical about the effectiveness that collective bargaining has having so far in bridging this gap. Perhaps it will take time also for in this case. Davide Tardivo, again on digitalization, and pointed out the relationship, let's say, the role that collective agreements may play in 3 different areas of intervention. You mentioned training and job description in the first place, pointing out the good examples of the collective agreement for the metal sector in Italy, and even some collective agreements in the service sectors. Also, the role in the second area, you mentioned that of union rights, and some collective agreements are already providing, making use of the digital tools, as for example, Davide mentioned the right to assembly. And so as a good opportunity for unions to exploit the advantages of new technologies as the employers are already doing. And also in the third area, again, we have to be disappointed, because as for algorithm management and data processing, which is very important aspect for trying to address the challenges posed by aggressive managerial practices in the working places. Davide also told us as very little or even nothing is happening in this field. And perhaps again here, the directive on platform workers can give a relevant input as for the development of collective agreements aimed at addressing the challenges stemming from algorithm management and those aggressive managerial practices I mentioned before. Last but not least, Matteo Turrin dealt with industrial relations and new technologies, and he showed the 2 sides of these relationships, so the conflict side and the collaborative side. We already have had very good examples of the conflict side. So on the one side, again, the aggressive managerial practices, so facilitated by algorithmic management, and also how the unions and the collective representatives of workers can use the tools, the digital tools for organizing collective action, or even just for communicating with workers, or even they can also be even used by workers to communicate among themselves, as platform workers have been doing very well. And moving to the collaborative side, there are, so Matteo told us the possibility for management and the opportunity that management and labor may have to share goals and solutions. Again, we got here 2 examples, the framework agreement on digitalization, and also Matteo mentioned the pact for factories made by the Italian social partners. but again, we have seen little on the collaborative dimension of that may take place on new technologies. So perhaps it's a matter of time, Matteo said. And again, as Philippe said at the beginning, the evolution of EU collective labor law takes time. So perhaps we need to wait. The problem is that we don't have much time. I mean, the digital revolution is moving forward very fast. The outcomes of the digital revolution are already in place. And just to conclude, I was in San Francisco 1 month ago, and I have seen these self-driving cars going around the city, and delivery robots that are tested in LA. And this made me think about the fact that the labor displacement, mass destruction of work that the techno-pessimists are predicting is not very far, perhaps is around the corner. And so I think it's time for the social partners, but also for the legislations to act, and to act very quickly, because perhaps time is tight, and very soon we will be assisting to some kind of dystopian scenarios which will have a very huge impact on the social situation. Okay, I think that's it for today. So I would like to thank again Alberto Pizzoferrato for inviting me to the seminar, and also it was a pleasure for me to listen to all the presentation and had the chance to provide some not very useful conclusion, but that this is what I've been able to do. So thank you very much.
Thank you, Emanuele, for your accurate and sensible conclusions. Yes, I think you have. We have not much time, and for the recovery plan, we are almost out of time. That's the danger. Please, Alberto. Alberto,
No.
it's up to you to say
you.
the final words.
Thank you to Emanuele. He is very brilliant. He has taken very good conclusion. So I have nothing to add. I, of course, agree with him. We have not much time more, but something has been done. We have listened to all these smart presentation, so we had some elements to reflect on. So we didn't waste time at all. We used time. Probably we need to go on, but we have to be optimistic, as some speaker said before. With this seminar ends officially my course in labor law, in my teaching at the course of legal studies of the University of Bologna. To my students attending this seminar, if you have any need, please send me an email. Otherwise, we will meet for the final oral examination. I conclude only thanking very much all the speakers, very good speakers that confirms me the choice we have done. So thanks again to all of you, and see you as soon as possible. Bye to everybody. Ciao Fiorella.
Ciao Alberto.
Ciao,
Ciao,
ciao.
buona giornata.
Grazie a voi.
Grazie, arrivederci.
Arrivederci a tutti, grazie mille.
Grazie a voi.